Why don't we start with the Pledge of Allegiance? United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Maria, Ms. Varela, the board secretary, formally, was the notice for the special meeting appropriately published where it should have been?
Yes.
And done so in a timely manner?
Yes.
That being the case, as the presiding officer of the special meeting of the West New York Zoning Board of Adjustment, I do hereby publicly announce that the notice requirements provided for in the Open Public Meeting Act have been satisfied. Further, I direct that this announcement shall be placed in the minutes of this meeting. Notice of this meeting was properly given by the West New York Zoning Board of Adjustment as attested to by its board secretary, and was appropriately published in the Jersey Journal, publicly posted on the municipal bulletin board and filed with the town clerk. Roll call, please.
Kenneth Blaine.
Here.
Alberto Chapman. Ramon Moynihan.
Here.
Jesus Alvarado. Rosemary Fritz. Teresa Cruz. Here. Albert Martin.
Here.
Mohammed Al Maktoum.
Here. Looking at the agenda, the only thing on the agenda for tonight is the continuation of the Meridian Boulevard application. We were supposed to have Mr. Alonso, would you step forward? We were supposed to have an expert by the applicant concerning the size of parking spaces. Is he here?
No, Mr. Chairman, and at the last meeting, when we scheduled it for this evening, I agreed that if it was unavailable, because he does live out of state, that with waivers appearing, we would proceed with the council meeting.
Okay. That being the case, what we have left tonight is questions by board members, if they have any, of the applicant's experts. Then a 15-minute summation by both the applicant's attorney and the objector's attorney, and then the board decision. So I guess at this point, the first thing, Mr. Alonso and Mr. Tanchowitz, would you just step forward? I just have one question that's been concerning me. Yes, sir.
I'd like just to understand that you've been delayed 2 weeks, and this expert was promised to be here tonight.
That's correct.
So we just spent 2 weeks between May 6th
And today.
and, I'm sorry, today's the 20th?
Okay.
No,
Today's
May 5th, May 5th. Reading to this out-of-town expert.
And for some reason, he's not here tonight, and the board has accepted Mr. Alonso's statement. And now we're going to continue with the rest of the process as it relates to this application. The first thing I'd like to ask both of you is this, and at my age, I've actually written these things down. I'd like you to clarify something for the board as you two see it. Admittedly, this application was filed under the old or former West New York Master Plan. And the still existing West New York zoning ordinance, because a new ordinance has not yet been approved. Before the recent passage of the new master plan without a new zoning ordinance, which has not been approved by the town commissioners, considering the references made by the applicant's planner at the last meeting concerning some language in the new master plan, would the both of you agree that the planning board and the West New York Board of Commissioners were aware of this controversial and well-publicized application while they were authoring and considering the new master plan?
I can't answer that. I don't know.
You don't think that they were aware of it?
I don't know. I can't speak for them.
Okay. Would you disagree that they were?
I can't form an opinion. I don't know what they knew or didn't know.
Did you see this publicized at all in any newspaper?
The application?
Yes.
Well, it was publicized when we filed the application.
How about, were there any stories about the hearing?
There were, but I don't know.
Okay, no, okay, there were. Okay, so you don't feel comfortable assuming that the West New York Board of Commissioners read the newspapers and were aware of this application?
That would be an assumption, I have no knowledge.
Okay, that's fine. Mr. Cantor's, how do you feel about it? Yeah. I'm really going on the fact that I'm trying to get to the new master plan and whether or not you feel that the Board of Commissioners were aware of this hearing. This is the 12th night of hearings.
The State Board of Commissioners.
No,
You mean the
I'm
government?
talking about the town fathers
Government.
and the planning board. When they authored and considered the new master plan, whether they were aware of the 12 nights or 11 nights or whatever it was of hearings, or however many nights of hearings were going on regarding this application at that time. Maybe you can't answer that either.
Well, the author of the master plan was Joe Day.
Okay, when they approved it, when they voted to approve, the planning board, I understand what you're
My
saying.
understanding was that was still a, understanding based upon the document I saw, the fact that the document is on the website for many months, the fact that many of these hearings are the subject of videotaping. It seems to be a current activity of boards, not only here but elsewhere.
Okay.
Do I know without asking each member commissioner to show up? You would think, certainly in the town of West Newburgh, where I'm sure the commissioners take their duties seriously to make what's going on in the town, be aware of the speed with activities in the town, something that planning boards do, because the planning board's under more authority, knowing the local conditions and the circumstances that exist in the town, particularly as they relate to development. One, without necessarily asking each commissioner to raise his hand or her hand, say, I'm going to answer your question, one, I think you will raise the entirety of the circumstances.
Okay.
Answer that question.
Thank you very much. I'm going to ask both of you, would both of you agree that this was a very well publicized, if not controversial, application?
No.
You would not agree to that? I'm sorry, no laughter, please. Okay? No outbursts, no laughter. It's a very serious matter tonight, and we're taking it that way.
Controversial is a relative term.
Okay, not controversial, well publicized.
In terms of being publicized, I published the purpose of the notice.
No, I'm not talking about the notice,
I
I'm
know
talking
there were
about,
some YouTube videos, I don't know who saw those.
no, I'm not asking this all.
I haven't read any articles, I don't know.
Oh, okay, you don't know if there's any newspaper articles regarding these hearings?
I haven't read any.
Okay, okay, that's fair.
My recollection, Mr. Chairman, is first of all, again, one can draw reasonable inferences in terms of whether it was well publicized based upon the board's experiences to how many members of the public turn out for any particular application. I'm not sure on many nights when you have other applications going, so I can't say to you there are 3 people for other applications, or 20 or 30, or 40 people, it's on interest to how well publicized and how interest this kind of application sparks among the populace of West New York. That's one. Second, I believe I was given a courtesy copy of an article that appeared in one of the local, I think, weekly papers. I say it only because you have a picture of me.
Something like the West New York Reporter?
That sounds, I remember the article just because it had a picture of me.
Well, that's a good reason.
I think my appearance stunned me a little bit, at least was I.
Were you close to Mr. Alonso, because the two of you had pictures?
I don't recall, I just recall seeing myself in pictures, that doesn't happen very well. I can't, I have to go back to emails and everything.
All right, let me ask the next question. Would you agree that there may be some language in the new master plan that may relate to certain aspects of this application? For instance, as the applicant's planner mentioned certain recommendations at the last hearing.
I'm sorry, the applicant's plan?
The applicant's planner, he talked about certain recommendations being in the new master plan that affected this application.
But I think he said that in response to the question.
I'm not parsing words here, I'm just saying he said it. I don't care what he said in response to
The
it.
context in which you say something is important.
My question is, would both of you agree that there's certain language in the new master plan that may relate to certain aspects of this application? For instance, when the applicant's planner mentioned certain recommendations in the new master plan. Wow.
Unfortunately, in creating a record here, my answer is it's a vague question.
Okay,
I
let
don't
me-
know the reference that
Okay, forget about the reference, let me ask it this way. Have either of you read the new master plan?
Yes, sure.
Okay. Would you say that would you agree that there's certain language in the new master plan that may relate to certain aspects of this application?
Yes. I'll answer yes.
off the top of my head, I'm not.
Okay. Secondly, would you agree that board members may decide what weight to give to any such language in the new master plan as a current or recent application of any related language in the old master plan or still existing zoning ordinance?
I'm sorry.
Yeah.
Excuse me, for that. The easy answer to your previous question, you just asked before the answer was, if his applicant.
That's not necessary. We'll get to it.
Okay, I'm sorry, repeat this.
Yeah. Would you agree that board members may decide what weight to give to any such language in the new master plan that may relate to certain aspects of this application as a current or recent amplification of any related language in the old master plan and still existing West New York zoning ordinance?
I think that requires them to draw a conclusion, which I don't think that they're able to do. It's a question of time of application versus time of decision. Which ultimately is a legal question for the court to decide.
No, okay, but that's why I put it this way. I was looking for an answer as you see it. I understand that on appeal, the court's going to eventually decide this issue, but as you see it tonight, in other words, should we completely eliminate your planner's references to recommendations in the new master plan that may affect this application?
Again, I don't know the context in which he said it. I believe it was in response to the question.
Why would that
about the
matter?
master plan.
Why would that matter? All I'm asking you is, should we completely ignore his testimony?
Well, you need to give it whatever weight you think is.
That's all, okay. That's,
And then ultimately, if that's the basis for a decision, then
Right.
ultimately a judge will decide whether or not it was appropriate.
I agree completely, that was my question.
I think testimony about
Is what?
is relevant.
Is wrong. Okay, thank you, I appreciate both of you helping us out. Question, Maria? Next, I guess the only things we have left are questions by the board, and then a decision. Does any board member, except for me, have any questions of any of the experts of the applicant? Oh, and then we have summation. No? Okay, I have some questions. Mr. McDonough? You can help us out also. I'll take it that you're still sworn, and I'm asking you questions as the applicant's expert planner. You accept that?
I will accept that.
Oh.
Yes.
Number one, and this is something I've been thinking about, is there a difference in professional planning between quote, good planning, unquote, and better planning, quote, unquote? Let me give you an example, okay? From your argument. In other words, if there were two sets of plans, one was good planning, but the other was more neighborly or fit better into the neighborhood, would the second be considered better planning, although both were good planning? An example, let's say there are 4 houses on a block, all painted the same color. And you have 2 sets of plans to build a fifth house on that block. The first plan will construct a house the same as the existing 4, but will be painted a different, but not offensive, color, and would be considered good planning. However, the second plan would also build an identical house, but will be painted the same color as the existing 4 houses. Because the second plan was the same color as the existing 4 houses and fit better in the neighborhood, as opposed to having, good question, right? As opposed to having a different color but not offensive. Would the second plan be considered better planning, although also good planning, as opposed to the first plan that was good planning?
It's a relative term, it really is, because
I
one
agree.
may say that uniformity is boring, and it is actually good planning to introduce some sort of an anomaly or visual interest. But the real test before the board is whether this application is consistent with good planning, not whether one is a better plan than another, but whether this meets the statutory test under the positive and negative criteria.
Okay, well, we can agree or disagree on that, as the case may be. Okay, the second question is, so let's stay for that for a moment. So it would be your testimony that, a second plan that did not cause as much hardship on neighbors, on a neighborhood or neighbors in the surrounding building, would not be considered better planning than a first plan that was considered good planning.
To not
We're
really
talking
terms that
relative
we
again.
deal with on a regular basis. The test is whether the application before the board represents a better zoning alternative for the property. And I've given you a whole list of reasons why I believe it is.
Okay, so you would not agree that if there were a second plan that did not cause as much hardship on neighbors or on the surrounding neighborhood, that would not be considered better planning than what we have today?
I don't believe it's relevant to the consideration of the board.
My
For the
next,
test that's before you.
I didn't mean to cut you off, I'm sorry. My next question is, would you agree that all buildings along the east side of Boulevard East have extensive setbacks along the Boulevard East frontage?
I would not agree that they have extensive setbacks. There is greenery along the frontage, but extensive setbacks, no. I haven't noticed that. There's a pretty solid street wall along Boulevard East.
Along the east side?
Along the east side, it says right in your master plan that it's parkland.
Well, you have the Versailles, you have Tower West, and you have the Riviera Towers.
Those are the clusters at the corner that I'm
That's not my,
exactly talking about putting another complementary
Okay.
building.
that's not my question. My question is, that's the east side of Boulevard East,
Yes,
as opposed to the west side, where buildings, to a general degree, are built up to the property line.
yes.
Okay. So on the east side of Boulevard East, would you agree that there are in fact extensive setbacks? For instance, would you disagree that right across the street, that the setback for the Versailles is over 25 feet?
I would agree with that statement, and I think it reinforces what I said last time about the recommendation in the new master plan, whether it applies or not, is actually reinforced by the finding by the planning board that a separation of 80 feet, building to building, is appropriate for buildings that are over a certain height. By virtue of that setback on the opposite side of the street, again, with a variance application, we look at the particular attributes of the property. This building is set back 80 feet from the one across the street. It meets that recommendation.
So you're comfortable meeting the requirements of the new master plan with an 80-foot separation between buildings?
Yeah.
Okay. And to use your terms, neighborliness and fitting into the neighborhood often, I assume that it's important that the building do that.
Neighborhood compatibility is a key part of the variance application, particularly on the negative criteria side, yes.
So since this is new construction, why do you consider not having any setback along the building's Boulevard East frontage to be neighborly or fitting into the neighborhood when all buildings along the east side of Boulevard East have extensive footage setbacks?
So we're on the west side and we're following a pattern.
Okay. All right, last week you talked, and you just spoke about it also, about a recommendation in the new master plan that relates to separation, I think you said of 80 feet
Yes,
between buildings, high-rise buildings.
yes,
Could you find that language for me?
sure. I'm on page 33, middle of the page.
Could you read the language?
Sure, to preserve view sheds, it is also recommended that there be a mandatory separation distance between buildings over 80 feet tall. Both buildings will be over 80 feet tall. The recommendation is that portions of buildings over 80 feet tall be separated from other buildings over 80 feet tall by a distance of, 100 feet in any direction, which is what we'll still comply with.
So when you spoke about you'd be satisfied with meeting the new master plan by having a separation between buildings of 80 feet, you misspoke.
I actually meant 100 feet, correct.
I couldn't tell that.
Thank you for the clarification.
You're welcome. Okay. Would you disagree, or would it surprise you if I told you that the distance between the new building, which is built, I think we can agree, right up to the property line, and across the street to the Versailles, the front of it is, including the 25 feet setback, is 104 feet.
Sounds right. I checked on Google Earth. I didn't use a
So
survey.
we actually had somebody
Check it,
measure it,
okay?
because I didn't want to give you bad information like 80 feet, 100 feet, nothing
Very
like
good.
that.
Check on the Google.
I will suggest to you that are you aware of any other language in the new master plan that relates to Boulevard East or buildings along Boulevard East that would modify or in fact maybe nullify this recommendation that tall buildings 80 feet or over be 100 feet apart?
There's a number of references in the new master plan to the unique character of Boulevard East. It says, for example, on page 20, the future land use plan, item number 4, the north-south streets such as Palisade and Park Avenue are capable of higher density than the narrower east-west streets of the town. This should be considered in formulating the land use plan. This is a north-south street. And then the very next item says Boulevard East must be carefully planned to preserve its unique aesthetic appeal. Any new construction must be context sensitive. And go back to what I said on the very first day, we are context sensitive by virtue of what's there, across the street, and what's around us. This is a beautiful blend of what's around us.
Is there any other language that you can remember relating to Boulevard East as opposed to the 100-foot recommendation?
There's only a recommendation to the zone as a whole, not to this particular piece of property. Again, I call this out as a very distinct piece of property that stares at that building across the street. It's very unique and it has very distinct attributes as a comparison to the zone as a whole, which is exactly what a use variance is supposed to be.
Okay, and on that line, can we agree that I don't have it in front of me, the future land use map, I guess it's called, in the new master plan, keeps the same zoning district?
Yes, which is,
And since we don't have a new zoning ordinance, the new master plan, at least as of today, does not change the amount of variances that this project would need under the new master plan. You don't really have to think about that because at the last hearing we agreed.
I continue to agree.
I know, I mean,
My only point is, again, the master plan relates to the zone as a whole. And we've heard that on the opposite side of Boulevard East is all parkland. So any tall building opposite that parkland would certainly impact the view shed. Here, there's no impact on the view shed because there's already a building there.
okay. Is there any other language that you can point to that relates to Boulevard East and the new master plan? You know, I don't want to play cat and mouse with you. Would you go to page 31 and read these, I guess it would be the second paragraph?
second paragraph, Boulevard East is a unique residential thoroughfare with housing ranging from single and two-family uses to mid-rise to the tallest high-rise structures in West New York. Although this is an unusual mix, in West New York it works because of the separation between the uses and the generally ample setbacks in the high-rise buildings. Also, the open space along much of the eastern side of the boulevard prevents a sense of being overcrowded. This unique aesthetic appeal must be preserved, and any new construction, again, back to must be context sensitive.
Okay, this is my question. My question is it your, based upon that language, okay, especially relating to ample setback, is it your position that the proposed newly constructed high-rise building does not have to satisfy the description of having an ample setback on Boulevard East? Because the Versailles across the street has such an extensive setback of at least 25 feet, so as to meet the recommendation of 100 feet separation between the two high-rises.
Yes, it relates to the unique attributes of the property in question and what's around it.
So as a professional planner, that is really your position?
Yes,
That the new project does not have to have an ample setback because Versailles does?
that's the mitigating factor. Again, my consideration of the application as a whole relates to everything, relates to all the reasons that I've given, not just that.
Okay, I think I only have one more question. The present application has about 20 variances, is that correct?
I'll agree with you, yes.
Would you consider that to be a lot of zoning? If I hear another laughter, I'll ask you to leave. All right, we are serious tonight. Would you consider almost 20 variances to be a lot of zoning ordinance violations for a project to have?
No,
Oh, you would not?
I would not.
Okay.
Especially, and we've dealt with every one of them.
All right, let me ask you. I'm not saying that. I'm not saying you haven't dealt with them. That's not my point. I wasn't going there. All I'm asking is, and I'll ask it, at what point as a professional planner would you consider a project to be so grossly outside the scope of the zoning ordinance that approval of it by the zoning board would be impermissible as the zoning board legislating in the place of the town father? How many variances do you need? 30, 40, 20?
It's a qualitative analysis. I think Mr. Kantorowicz asked me the question of, a similar question as I've had an application with 99 variances. So again, I just remind the board, it's not a quantitative analysis, it's qualitative, and we really need to look at the big picture.
I agree. I agree that it's not only the number of variances, but it's also what detriment, if any, they have regarding the welfare, the general welfare of the town, as well as the zoning ordinance itself.
Yes.
I have no further questions. Does any other board member have any questions? Not seeing, then thank you very much, Mr. McDonough. I appreciate your answer.
Thank you.
Next, we'll have the summations. Does anybody want to give me a hint as to who goes first?
Kantorowicz goes first.
The defendant goes first. I mean, Mr. Kantorowicz goes first.
I go first.
And each has a limit of 15 minutes.
Microphone.
Right, microphone. Yes, I'm sorry, the testimony is closed. There are no more witnesses, the testimony is closed, the board has asked us questions. The one expert witness tonight couldn't make it again, and Mr. Alonso has waived that testimony, and we're proceeding accordingly, as planned. The only thing we have left now are the summations, excuse me,
And,
by the attorneys. And the-
another housekeeping issue.
Sure.
We need a microphone, so.
Sorry about that.
See, when you say housekeeping, people
Yeah.
perk up their ears.
one other housekeeping issue. I'd like to know who I'm pitching to, so could you tell me who's voting on this tonight?
Everybody, all board members you see up here are voting. We have 9 board members, which is 7 and 2 alternates. Ms. Berto has to recuse herself, and Mr. Garcia is not here, and I guess what you said, it's not replaced.
Yes, he's not eligible. As you pointed out, he didn't take his land use course. So under the land use
Within
law,
time.
So he's ineligible, he is not here, so we cannot.
So we have 7 members here at present, which I guess would be the 6 regular members and 1 alternate.
And everybody who may or may not have been at all the meetings has certified,
They have signed
taken
the,
care of the appropriate.
yes, they have signed the appropriate certification
Okay.
that Mr. Boris, our board attorney, dutifully prepared, I'm gonna say, 10 minutes after the meeting was supposed to start.
I'm only asking because the last time we met,
There were questions.
there A, there were questions, and B, I was not aware that there had been transcripts produced, since I generally would contact either the board secretary and the town through an open request, or your board counsel was gracious enough to furnish me with copies of transcripts. And between then and today, I wasn't aware that the last 2 meetings had been transcribed and where the transcripts had been produced. But if you tell me the transcripts have been produced, and
Transcripts are produced.
you have certifications,
The certifications are with the board secretary.
okay. Good. This is a land use application, and the most significant thing you need to know about the land use application is what the standards the applicant has, what are the standards that the applicant has to meet? And has the applicant presented proofs to meet that standard? Now, you heard the chairman indicate just a couple of questions ago that there were a lot of variances. And the standards are pretty straightforward. There are positive criteria for every variance, and then there are negative criteria. They're set forth in the standard. The positive criteria is that the grant of it would substantially, let me quote the languages, I don't want to misstate it. Positive criteria, where the purposes of the ZAP would be advanced by a deviation from the zoning ordinance, and the benefits of the deviation substantially outweigh any detriment you grant a variance. So if they're asking for a variance because of side yard setback, and you know that there was no side yard setbacks, then you need to know and find, based on evidence that you've heard, that there are benefits that are coming from the grant of those variances that substantially outweigh any of the detriments. Okay? And the benefits we speak about are not private benefits. The benefits we speak about are the benefits to the community, to the welfare and the good of the community. It's not simply measured by, is it a benefit to this particular developer. The negative criteria that you have to find for every variance is that no variance can be granted, without a showing that it can be granted without substantial detriment to the public good, and it will not substantially impair the intent and purpose of the zone plan and the zoning ordinance. So those are the standards. You have to start looking. Now, what is rather unusual about this application is that not only does it ask you to grant variances for every single standard, it asks you to grant the variance for the minimum lot size, to half the minimum lot size to do anything other than a burning permit. It asks you for proposed density. That is, by my calculation, 15 times what's allowed. Because I'm operating on the assumption, you heard the testimony, that you don't automatically assume that they're permitted to do an elevator here. They're not. The reason you don't automatically assume it is because they haven't shown you that you get to automatically assume you get an elevator and then go on those densities. Whereas what you're going to hear on the other side, and what they put in their application, was that assume we've gotten the 40,000 square foot variance past you, and now compare what's the requirements of the 40,000 elevator building versus what they're doing. We are saying to you that's not the correct measure. The correct measure is looking allowed now, what they're allowed to do now in most dense uses of apartment park. It's 20,000 square foot lot. So the densities, just to give you an idea, 20 units to the acre versus 334 units to the acre. I'll just repeat that since that sounds rather jarring. 20 units to the acre versus 334. Even if I concede that you're allowed to do a garden apartment, you're looking at 80 to the acre versus 334 to the acre. They're undersized with maximum width of the lot. They're undersized with no front yard setback. They're undersized with a minimum side yard. They're undersized with a rear doesn't apply. They're undersized with the height. Same thing with the height. The garden apartment height is 35 feet. They're asking for 153 feet. Even if it were a required apartment, they're still a full story and another 18 feet over. Same thing with building coverage. Even in a garden apartment building coverage, 75%. This is a 97% building coverage. And yet, garden apartment's 35%. So my case is a very strong one in terms of what the substantial detriments are, even under their, what I consider to be erroneous measure of comparison. I go on, parking stall size and the like. You heard our expert discuss this. The other point that you need to understand, and I'd like you to appreciate, is this. As we read the zoning ordinance, we think it's correct reading. The size of the property is integral to the use. And I'll give you a very simple analogy you can wrap yourself around. Okay? We would all agree that a Home Depot sells hardware goods, plumbing supplies, tools, and the like. And we also all agree that a local hardware store sells the same items. So in a sense, we could say the Home Depot is like the hardware store, is what it does. Yet, many ordinances around the state will classify a big box Home Depot as a completely different use from a hardware store, a local hardware store in a commercial district, because the essence of what's going on, because of the essence of the use itself. And the way your zoning ordinance reads and is written, the 40,000 square feet is integral to an understanding of use. They don't have it. They claim they don't need it. They claim they don't need a D1. We think they need a D1 for that. We also happen to think they need a D1 for the mention that your board chair just said, which is when you come to a site and you ask for every single standard to be varied, and not by a little bit, but by a lot, you're really asking for a rezoning. And that's not your function. That's not the governing body's function. And there's case law to support that progeny from a case called Dover versus Board of Adjustment. And in fact, your ordinance recognizes that. Your town fathers have recognized that. Why do I say that? Because in fact, as you're aware, there is something called an infill district. So they recognize when they want to create a zone that has its own standards all by itself, they did it. They didn't do it here, but rather your master plan, the aspirations of what the planning board is guiding you, reiterated that the zone district here stays the same. Zoning for this property stays the same as an articulation in zoning criteria as to what the master plan is writing in its narrative about the unique appeal, the special character of the East Side. In sum, what you have here, you've all been here a lot, is you've got, in very broad terms, an effort to pour not 10 pounds of sand into a 5-pound bag, but 15 pounds of sand into a 5-pound bag. And it's your task, as you know, is to evaluate that. Is there a substantial detriment or not? Now, I will make a couple brief comments that you made here from the other side about summation. Mr. Rainkamp is a planner. Mr. Rainkamp focused on the negative criteria pointed out through his analysis of the master plan, the zone plan, the actual development, and the standards. His testimony was based upon his being here repeatedly, and he testified that he had either been here physically in the room or read transcripts of all of the testimony. And what planners do is they listen to the testimony and then they speak about it. He spoke about it from a planning perspective. He did not speak as an engineer. He spoke as a planner, and he was very careful in speaking to you about the planning criteria of the negative, excuse me, the planning aspects relating to his view that the negative criteria were not met. So it all boils down to this. There's a lot that you have to digest, but it all boils down to this. Putting aside the critique that the application is deficient on its face and can't be approved because it fails to comply with the zoning ordinance for affordable housing. Regardless of what you say about legality, it's there, and it fails to comply with the requirements for RSIS standards. And of course, they cherry pick standards by wanting RSIS to apply to a number of the spaces, but not to the size of the spaces. And no one has ever justified the size of the spaces based upon recognized literature in the field. But having said all of that, they want you to accept that somehow this is all good, notwithstanding, and you can judge the credibility of your fellow citizens. You can judge, you know. But they want you to accept somehow or believe that there's no substantial detriment by pouring this much onto this property in a zone that's not zoned for. I'd be making a completely different argument if the applicant came in and said, you know what, we acquired the Dado building, we got a larger lot, you can make a smaller footprint, put some side on it, not go up as high, move, set that back, do all sorts of things. But they didn't do that. They acquired another property as compared to what they had done previously. They have now 3 lots. We're going to get rid of 2 conforming uses, and they are going to their proposals to max out the waterway to the side. Nobody told you why. Planner said it's contextual. It works because Versailles is here, and we're here, and the single families are here, regardless of what's on the side. It's not contextual. But they never told you why that's happening. Who's benefiting? Who's getting a benefit? Did you ever hear who was getting a benefit? No. But you heard myriad testimony about detriment from Mr. Ray White, and then you heard him discuss the planning aspects of analyzing the negative criteria. In sum, if this were a different application, I'd be talking differently. It's not. It's an application that is egregious in its overreach for variances of every single standard, and one that cannot be justified through a objective review of the evidence. I believe the evidence just doesn't support granting each and every one of these variances. For example, let's conclude with this. You have to show how various variances that are creating detriments are being resolved, so there's not to be associated problems. You didn't hear that about complexity of parking. You didn't hear that about lack of guest parking that's required under the RSIS. They never spoke to that. You didn't hear about that about loss of on-street parking spaces. You didn't hear that about the absence of the loading zone. You didn't hear that about any of the congestion. You can judge for yourselves. What you heard was essentially it's contextual zoning. We think it works, and frankly, that's a lot of, to use a phrase, a lot of empty zoning can to be pouring this much sand into this small bag. I'd ask you to listen, review in your minds what you've all heard, and deny the application, because at the end of the day, even if we never stood up, you have the burden of deciding that the applicant met its burden. We don't believe the applicant has met its burden. It just hasn't. As I said, I'd be singing a much different tune if the dimensions were different, if the setbacks were different, if what was being asked to be put on this building was different. But it's not. It's completely maxed out in every single way to the substantial detriment of the zoning plan, the intent and purpose of the zoning plan, and the zoning ordinance, and the HDD. Thank you. Thank you.
Thank you, Mr. Cantulis. Mr. Alonso?
Good evening, Mr. Chairman, members
Good
of the
evening.
board. I apologize in advance if I start coughing, I have an
If you
allergy.
start coughing and have to take a couple seconds, please feel free.
So first of all, I want to just thank everybody for being.
The reason why I say that is I think we did the same thing at the last meeting or 2 meetings ago with the objectives plan. So we'll certainly give you the same courtesy.
Thank you. I just want to thank everybody for your time and the courtesies that I believe you've shown, not only myself and the applicant, but also Mr. Kankowitz and the public. This is our 12th hearing this evening, and I think part of that has to do with the amount of time that you wanted to make sure was allocated to this application, because it's very important, not only for my client, but also for the residents of West New York, and I thank you for that time. Now, I briefly want to say that with respect to the issue as to whether or not this is a permitted use, and whether or not the master deed confirms it or doesn't confirm it, not master deed, new master plan, okay, it hasn't changed. A high-rise building is permitted on a 40,000 square foot lot, assuming we can assemble the 40,000 square foot lot on our block, it's permitted, irrespective of whether or not there's a canyon effect or it should be in front of the side or not. It's permitted, and that hasn't been changed by the new master plan. And now it's time for you to decide this case. And after 12 hearings, I'm not going to sit here and try to repeat or reiterate all the testimony that was presented by all the witnesses, the arguments. I submitted a summation to you, which basically says forth my legal position as to why we've proven our case. One of the things that Mr. Kankowitz did was he basically highlighted the deviations. We know what the deviations are. We testified as to the deviations. We know what we're required to have in the zone, and we know what we're proposing. But that's what he did. He highlighted. He didn't talk about the facts that supported it. And the facts are very important because it's my understanding that no matter what happens before this board, we're probably going to go up and appeal one way or the other. And hopefully, the board grants the application and we're on one side and Mr. Kankowitz will still be on the other side. But the judge is going to look at the board's actions relative to the facts. You need to determine what those facts are. There was testimony and arguments made on both sides. Okay? We can't all be right. Somebody has to be right, somebody has to be wrong. And you need to make those factual findings based on the credible evidence and the testimony presented. Okay? I submit to you that our side is credible. And you heard the credibility issue that was raised by Mr. Kankowitz as well as a number of objectors or public members when they came up before the board. They just didn't agree with us. They didn't believe what we said. It's not believable. But all the testimony presented on behalf of the applicant was based on studies that were performed by engineering principles, by planning principles, and is all supported by facts. I submit to you that on the other side, there was a lot of emotion. And I understand the emotion, because that's where the people live. But you also have to understand the credibility of the public. And I provide as part of my summation a list of all the public members who appeared before the board. There were a total of 18 members who came from the Versailles. They either asked questions, they made comments, or both. If you look at it, 18 members out of 280 units, it's only 6%. There was an argument that there was a lot of outcry. It was very contentious. A lot of people, nobody wants it. But 6% of the units were represented. If you look at the total population of Versailles, it's probably a lot less. In terms of the other residents, you had 5 members from the Halifax and Stormgate, and there were 7 other people. Okay, 3 of them were from out of town, or from the city. 2 were from North Bergen. Mr. Ortega, who lives in a 30-story building. The guy from North Bergen lives in a 30-story building. Okay, so you have to assess the credibility. And when you argue about the motive and the interest that we have, well, they likewise have those motives. Otherwise, they wouldn't be here. And the motive and the interest is that the majority of those people from the Versailles live within the first 12 floors. So what happens is they too have a motive and an interest. So you need to assess the credibility of who said what and how it was in the context of which it was said. Now, there were a number of issues that were raised by the objectors. I believe that based on the evidence, we've supported them with credible testimony. There was an issue with respect to the shadow study. Now, the shadow study was interesting because it all really dealt with the location of the pool. That was really the focus of the crux of the arguments that were made, not necessarily on the balance of the neighborhood. And the location of the pool, we understand, is on the north side of the building. And we know that when you're going to install a pool, you should put it on the south side of the building. And when you look at the shadow study that was presented by the applicant, there was no impact on the pool if it was located on the south side of the building. So they want to penalize us for design. Now they're saying, well, it wasn't a poor design, it was designed like that on purpose, because one member said it was poor soils. Well, if there's poor soils there, how do you build a 29-story building? You can support a 29-story building, you can support a pool. Somebody else said, well, it's because there was a sewage treatment plant, and we don't want to smell the sewage treatment plant. We show photographs from 1979, there was no sewage treatment plant at that time. This building was built in the 1960s. So you listen to the credibility and the emotional arguments. Is it credible? Is the arguments based on fact? Or are they just arguing and giving you an emotional plea? Now, again, with the parking, the same thing. And by the way, they didn't perform their own shadow study. They criticized ours, which they have the right to do, but they didn't rebut it or refute it with their own shadow study. There was an issue with respect to the parking. Depending on who you listen to, which is members of the public, there was up to 40 parking spaces that were going to be lost as a result of this new building. That's physically impossible. Again, arguments made without any basis in fact. We provided a traffic study. They provided no traffic study. All they did was say, we don't agree with you, Mr. Carabelli. You don't live here. You don't know. You don't understand. But rather than getting their own traffic study, which they did at the last couple of meetings, I was talking to Mr. Simon, who was their traffic expert last time, but they didn't bring on this time. They just argued without any basis. They raised issues with respect to the COA and the affordable units. I believe that this testimony is clear that there is no COA obligation because COA doesn't exist. We also represented on the record, if there is an affordable component, if there is a legal requirement, we would meet that legal requirement. So there is no affordable housing issue. There was arguments about tax abatements as to whether or not should I make this application because my client would apply for a tax abatement. That is not an issue to be considered by this board. That is something before the Board of Commissioners. If the Board of Commissioners wants to grant it, it's up to them to grant it. They argue that a tax abatement will result in decreased revenue. That's not true. As a matter of fact, there will be substantial revenues, even through the tax abatement period. Okay, and after the tax abatement is over, then we will be paying 100% moving forward. We also talked about negative impacts on their property values. Again, not supported by any expert testimony. It's their position that the values of the properties will decrease. Anybody who's been in this area for a long time knows that property values continue to rise. There's a lot of development going on. And is the property values going up because of developments? I believe so. That's the only conclusion that you can really draw. But there was no expert testimony to support their position. They also came and argued about the canyon effect. The problem with that is there is no engineer who testified as to the canyon effect. Those of us who like to watch the History Channel, the Nature Channel, and there's other channels on cable, you see these things. They do modeling. There's engineering studies that are performed. None of that was presented to this board. I don't believe that this board can conclude, as a matter of fact, based on the credible evidence, that there is a canyon effect. Now, they had one expert witness testify, Mr. Rainkamp. Mr. Rainkamp testified that he's not a traffic engineer, he's not a civil engineer, he's not an architect. He acknowledged that the objectors did not present any such testimony from any licensed or qualified witness in any of those fields. And basically, there's no factual basis from which he can draw the conclusions that he did. All he did was he reviewed our studies and says, I don't agree with it. Well, why don't you agree with it? There has to be a basis for you not to agree. And what is the answer? He didn't do that. Now, he only focused on the negative criteria, if you recall his testimony. There's a negative criteria and there's a positive criteria. Does that mean that they concede to the positive criteria? Have we met that? Because otherwise, that testimony is unrefuted on behalf of the applicant. He also cites the Dover case, and he's of an opinion that too many C variances equals a D variance. There is no such formula in the land use law. Okay, because if you look at it, if you think about it, in this zone, we permitted a one-family house on a 25 by 100 lot. If the lot is 24 by 100, and I don't meet that, does that mean I need a D1 use variance because I don't have the lot size? Absolutely not. And that's why the arguments that they made in terms of the D1 use variance don't fit. Now, in closing, I believe that we met our burden. The issue is whether or not this site can accommodate the issues that will arise from the granting of the variances. I believe based on all the testimony presented by all the witnesses, direct examination, cross-examination, rebuttal testimony, whatever, I believe we met that burden. And I ask you to please make the right factual determinations based on the credible evidence. And I think the only conclusion we can come up with is that we met our burden under the municipal land use law and approve the application. Thank you for your time.
Thank you very much, Mr. Lund. Those are the summations of the two attorneys. The only thing that's left is a board decision. I would ask, does any board member want to make a motion to approve?
Chairman, can I have 2 minutes for secretary?
Yes? Mr. Attorney,
Yes.
is there anything else that you would like to do before we vote?
No, Mr. Chairman, thank you for allowing me the time.
So the board can now vote?
Yes, Mr. Chairman.
Okay. I would ask the board members, does any board member want to make a motion to approve this application? Not seeing any? I'll make a motion to reject this application and ask for a second. Is there a second?
And just for clarification purposes, a yes vote is a vote to deny the application.
To reject.
A no vote would be to approve the application.
Do we all understand
A
that?
little backwards.
A yes is a denial of the application. A no is a denial of the motion, and I guess an approval of the application because no one moved to approve it. So we have to do something, so we're moving to reject it. Okay? Roll call, please.
Kenneth Blaine,
Before I vote, I would like to express my reason. The application before the West New York Zoning Board is to construct a 13-story multifamily structure containing 157 units with 160 off-street parking spaces, which parking will be on 3 levels of the proposed structure. The subject property consists of 3 lots at the corner of JFK Boulevard East and 62nd Street in West New York. The 3 lots combined are a total of 20,444 square feet. The 3 lots currently contain a former gasoline service station now used for auto repairs and parking and residential dwelling. Directly across from the proposed building easterly on Boulevard East is the Versailles high-rise cooperative apartment building, which has 289 units in it, and directly across from the subject property northerly on 67th Street is a 6-story apartment building known as Halifax Hall. Also, across the subject property, the subject property is located on an RM or medium-density residential district with an RH or high-density residential district being opposite it to its east across JFK Boulevard East. Reading the applicant planner's report, this application requires approximately 20 variances from the West New York zoning ordinance requirements. More specifically, it requires a D4 variance for an increase in permitted floor ratio from the permitted ratio maximum of 3.1 to to the proposed ratio of 11.75, which in absolute numbers equates to the project's floor ratio of 240,217 square feet, whereas only 61,326 square feet is allowed under the West New York zoning ordinance. Also, a D5 variance for an increase in the permitted density from a permitted maximum density of 80 dwelling units per acre to the proposed density of 335 units per acre, which in absolute numbers equates to the project's 157 units, whereas only 37 units are allowed under the West New York zoning ordinance. And a D6 variance for a deviance from the permitted height of 12 stories or 135 feet to the proposed 13 stories or 150 feet. Also, the application requires bulk variances regarding the minimum lot area required of 40,000 square feet to the proposed grand total of 3 lot areas of only 20,444 square feet. A variance regarding the required 200-foot minimum lot width to the proposed 150-foot lot width. A variance regarding the required 15-foot front yard setback, or front yard, to the proposed 0 front yard. A variance regarding the required 15-foot rear yard to the proposed 0-foot rear yard. A variance requiring the required 17-foot side yard to the proposed 0-foot side yard. A variance regarding the required 75-foot lot coverage to the proposed 97% lot coverage. That should have been 75% to the proposed 97% lot coverage. A variance regarding the required minimum parking space size to most parking spaces proposed being sized much smaller, and for parking aisle width and variances for parking aisle width, handicap stall width, number of driveways, driveway width, driveway offset, number of signs, sign area, and sign height. Including tonight, there have been 12 nights of public hearings concerning this application, during which all parties, the applicant and the public alike, have had numerous opportunities to testify and express their opinions and views concerning this application. In fact, I hereby incorporate and adopt the testimony, concerns, and objections of all of the members of the public who made comments, especially those of Ms. Bryceland, Ms. Breakstone, and Ms. Tulipan, and the testimony of the objector's planner, and much of the reasoning of the objector's attorney in a summation, as though all were fully set forth in this opinion. Moreover, many members of the public asked questions of the applicant's experts and gave their comments and opinions regarding the proposed building, and all the public comments were, as far as I remember, negative and against the application. No member of the public expressed an opinion or gave a comment that he or she would rather see this building built than have the present status of the subject property kept as is. Only the applicant's experts gave a positive and favorable opinion of the change that would take place if the application were granted. However, the number of public commentators does not an application decide. The statutory requirements mandated by the New Jersey Municipal Land Use Law and the West New York Zoning Ordinance must be met. And the presentation by the applicant's experts was very professional indeed. The culmination of their testimony was the conclusion that this application meets the statutory requirements because the site in question can accommodate, as Mr. Alonso just stated in his summation, can accommodate the problems associated with the zoning deviations, and at a minimum, the benefits of this project outweigh the detriment caused by the deviations from the West New York zoning ordinance. I could not disagree with them more on both counts. Firstly, Regarding whether the site can accommodate the problems associated with the deviations from the West New York zoning ordinance, all one has to do is review the large number and substantial nature of the deviations as I have just stated them, and as far as I'm concerned, as one member of the zoning board, the only reasonable conclusion is that this project cannot accommodate the many problems created by this project, and most especially in light of the critical setback requirements that this project fails to meet and the failed sizes of the combined lots and the parking spaces. In fact, the West New York Board of Commissioners recently adopted a new master plan for the town that, as admitted by the applicant's planner, does not change, reduce, or lessen the number of variances required by this project, although the zoning board hearings on this project were taking place while the new master plan was under consideration and voted upon by the commissioners. I find this significant because the municipal town fathers were given an opportunity to change the zoning requirements to accommodate this project and chose not to do so. In fact, they kept the zone as a minimum density zone in the proposed future land use plan included on page 21 of the new master plan, dated December 1st, 2014, with a floor area ratio, or FAR, F-A-R, requirement of 5.0. Notably, also on page 33 of the new master plan, the high density would permit a FAR of 15.0, but the minimum lot size required is kept to 40,000 square feet. As stated again on page 33, and I quote, FAR, or the floor to area ratio, is currently used as one of the standards for elevated apartments in the medium density residential district in West New York. And we must remember that's where this project is. Higher floor area ratios are proposed to be allowed for tall buildings or larger lots, such as in the TOD area, and lower floor area ratios will be allowed on smaller lots. In general, the larger the size of the lot and the more open space that is provided, the taller the building may be. I would add that the proposed project's total lot size of 20,444 square feet is about only 50% of the size of the minimum high-density lot requirement, but its FAR, or floor area ratio, is almost 12.0, which is about 80% of that permitted FAR if it were in a high-density zone, which it is not. This project is in a medium density zone with a FAR of only 5.0. Consequently, to me, the approval of this application with the huge amount of variances required and the grave import of some of those variances to the substantial detriment of the West New York zoning ordinance would be an impermissible act by this zoning board to legislate a rezoning of the municipal master plan and thereby illegally usurp the authority of the municipal town fathers. For this reason and the other stated in my opinion, I make a factual finding that this site cannot accommodate the problems associated with the deviations from the West New York zoning ordinance presented by this application. Next, regarding the balance between the benefits of this project and its detriments, I don't see this even as a close call. The applicant's planner testified as to what he perceived to be the benefits of the project that helped to meet the statutory standards. However, in contrast to the testimony by the applicant's planner regarding the benefits of this project, stands a substantial detriments, which I find as a fact greatly outweigh the stated benefits. Firstly, as I have already indicated, I find that the failure of the project to meet the setback requirements is very detrimental to the quality of life of the subject neighborhood, immediate area, and to this iconic boulevard in general, and to green good planning concepts that should be met. I find that the purposeful elimination of the side yard and front yard setbacks in new construction as the present project on one of the most scenic roadways in all of New Jersey to be a substantial departure from the purpose and intent of the West New York zoning ordinance. It seems to me that the applicant's planner relied on the lack of front landscape setbacks for the buildings along the western side of Boulevard East, while ignoring the extensive front, beautifully landscaped setbacks for the buildings along the eastern side of Boulevard East to justify the quote neighborliness unquote and quote good planning unquote of the proposed building's lack of a front landscape setback, which in my opinion creates a devaluation of the property values and scenic beauty along this iconic boulevard, only for the benefit of enhancing the financial return of the proposed building's development. As boldly and pointedly stated on page 31 of the new master plan specifically relating to Boulevard East, which certainly expresses the reverent view of the town fathers regarding this iconic roadway. Quote, Boulevard East is a unique residential thoroughfare with housing ranging from single and two-family uses to mid-rise to the tallest high-rise structures in West New York. Although this is an unusual mixture, in West New York it works because of the separation between uses and the generally ample setbacks of the high-rise buildings. Also, the open space along much of the eastern side of Boulevard East prevents a sense of being overcrowded. This unique aesthetic appeal must be preserved, and any new construction must be context sensitive. End of quote. Moreover, this description is nothing new. It is merely a descriptive statement of the reality that is Boulevard East in West New York. For my reasons given in this opinion, I find it a fact that the proposed new construction project does not have ample setbacks and instead does create a sense of overcrowding so as to degrade the unique aesthetic appeal of the special West New York Boulevard and not be context sensitive in any way, shape, or form. Further, if approved for the specific site on Boulevard East, this project will set a very bad planning precedent by, for the very first time, creating a canyon effect in that the proposed building will be face-to-face with another high-rise building, namely the Versailles Cooperative Apartment Building, on a relatively close and narrow portion of Boulevard East, and create the very kind of claustrophobic and overcrowding atmosphere that does not presently exist anywhere else along Boulevard East and West New York, and about which the new master plan expresses concern. For those wondering, I don't have much more to go. Secondly, in my opinion, any benefit that I heard the applicant's planner testify to immediately falls when compared to the great detriment and harm caused by the project to the quality of life of almost 300 Versailles residents and the value of their cooperative units due to the imposition of shadows from the new building onto the Versailles pool deck and swimming pool during the late afternoon and early evening hours every weekday and every weekend in the summer, as exhibited by the applicant's own sun shadow study. To me, this destruction of an asset valued by hundreds of the town's residents overwhelms any professed benefit. Also, as brought out by the objector's attorney in cross-examination, it would seem to me to be more neighborly, if not better planning, to have moved this building a few feet to the south and thereby lessen, if not possibly totally eliminate, the effect of the shadows of the proposed building on the Versailles pool, as well as the southern apartments in the Halifax Hall, while acknowledging that such a restructuring may have lessened the financial return to the proposed building's development. In addition to the above reasons, Other items that I find the proposed project, other reasons that I find the proposed project a substantial detriment to the public welfare and substantial departure from the intended purposes of the West New York zoning ordinance include: 1, the dumping of approximately 2/3 of the newly provided for 160 automobiles onto 67th Street, a one-way narrow street that exits without a stoplight onto the heavily trafficked JFK Boulevard East, and 2, the proposed balconies overhanging the sidewalk on Boulevard East in West New York, with the very real and well-recognized public danger that this situation will cause, again, only for the benefit of the increased financial return of the proposed building's development. So in conclusion, after carefully reviewing and considering all of the testimony and comments, and for all of the above reasons, I find that the applicant has failed to meet its legal burden regarding the proposed project, and I vote yes against this application. I vote yes in favor of rejecting this application. I do not make this decision or take this vote lightly. I do not do it for my own political interest, or my own professional interest, or my own economic interest. I make this decision because I believe it is the right thing to do for the best interest of all West New Yorkers and the value that is placed on this very special area in our wonderful town that will be degraded, in my opinion, by the very many zoning ordinance violations and problems of this project and the unnecessary enormous size of the proposed building. Now, turning to the other board members who may also vote yes in favor of rejecting this application, I assume you will have adopted my reasoning, but should you, of course, feel free to state any additional reasons that you may have if you choose to do so. Next.
Jesus Alvarado. Alberto Chapman.
Yes.
Elmer Martin.
Yes.
Mohammed El Maksoud.
No.
Teresa Cruz.
Yes.
Ramon Morejon.
Yes.
What is the vote?
Yes.
So this is not necessarily a cause for celebration. It's a serious business before the zoning board. Please treat it as such.
Who seconded the motion?
Alberto.
Sorry, yeah, that was my,
There's no further business before the board except.
we can open the meeting to the public, general.
All right, we'll open the meeting to the public for brief general comments regarding behavior.
Just on my way out, I just want to say thank you all.
Thank you, Mr. Brown. Thank you. Excuse me, should we wait for everybody to leave, or how's this gonna play out, because we can't hear the commentary? I would just ask you, please not to have conversations in the chambers. If you want to, please have them in the hallway. Thank you.
I want to thank the board, especially you, Mr. Blaine, for your wonderful objection to this application. I spent many hours going to the meetings, and I researched the developer, George Capadocli, and my thing is you, even if there were no objectors, no members of the public, you represent the people of West New York, period, not the developers.
Thank you.
I'm not finished yet. And the thing is, if George Capadocli comes again with another application to the West New York Zoning Board, you would seriously consider my testimony January 22nd. Practically most of it was from public documents over request.
I'm sorry, but you would have to make your testimony again.
Okay, but just consider the record of any developer who
Thank you.
makes
Thank you.
an application. Thank you.
Anybody else like to make comments regarding behavior of the board? Not seeing any. I'll let Mr. Bowman. I thought I was gonna get away like.
Patrick Cullen, 72 67th Street. Patrick Cullen, 72 67th Street, West Newark, New Jersey. Was the vote 5-2? I don't think that was.
Yes, the vote was 5-2 in favor of the resolution rejecting the application.
I would just like to thank the board for its due diligence. On 12 nights, I thought of the Shakespeare play, Twelfth Night, and which opens up with the lines, "If music be the food of love, play on." I would submit to you that we have made beautiful music as an American democracy. If Aaron Copland were here in the audience, he'd be playing one of his masterpieces. I think that this is democracy in action, and I think that we have made some great music together. And just as Humphrey Bogart said to Claude Rains as they're departing the runway in the greatest movie ever made, Casablanca, this is the beginning of a beautiful friendship. And my words still ring true, that when they come to try to take some property rights away from you or some convenience rights, they try to take away your parking rights in your neighborhood, we will be there for you. Even for the ones, the 2 people that voted no, we will be there for you. I want to thank you for your due diligence, and God bless America, God bless West New York.
Thank you, Mr. Cullen. Hopefully not seeing any other member of the public who wants to make a comment regarding the board. I'd just like to say one thing, that I am very proud tonight to be a member of this board. I think it took a lot of courage. I know it took a lot of courage for those people who voted yes. And I would just like to say that I'm equally proud of those people that voted no, because they were also a member of our West New York Zoning Board family, and someday they will see the light. But we still embrace them, and we look forward to having many more similar meetings where this zoning board does in fact the right thing for the people of West New York. Based upon that, I will entertain a motion to adjourn. Okay, I move to adjourn. Is there a second? Yes. Okay, all in favor? Aye.